This is the current federal tax developments for the week of June the 24th, 2018. Current federal tax developments are brought to you by Kaplan Financial Education and by your state society of CPAs. I'm Ed Zollers, and this week we're going to be looking at various things happening here in the area of federal taxes. We're going to start out with the discussion of the Section 199 Cap AG proposed regulations issued by the IRS along with a notice. We'll then move on to the Supreme Court's decision. Again, second straight time on June 21st, they've issued a big decision, this time on a state's ability to tax a trust. The Kastner Trust case, we'll discuss results there. We'll talk about a claim of right case from the 11th Circuit. Claim of right is something we run into from time to time, discuss what that is, why it mattered in this case, and what the result was, and finally close out with electing small business trust issues for non-resident alien shareholders. That's the final regulations issued in that area this week. So with that, let's go ahead and start talking about certain issues that we have now coming up. Like, I'm going to be heading out to Portland, Oregon. I'll be heading there to do a couple of courses this week. I just finished this past week in the tri-state area, New York, Connecticut, New Jersey, and did a couple of courses there, one in West Orange, New Jersey, another one in Shelton, Connecticut. Got a couple of days there, and I'm going to go to the other end of the country and go to Portland, Oregon. And actually going to be in Beaverton, Oregon for the Oregon Society of CPAs at their offices. I'll be doing a pair of courses this week. The first course will be on fringe benefits. It will be held on June the 27th, Fringe Benefits 2019. We'll talk about what's happening there, how things are working. We'll also talk about those HRAs that were established, the individual coverage HRA, whether that's something you want to consider using, how it works. So if you want to talk about those sorts of things, you can show up there. We'll talk about other items, the fun with reimbursing employee meals. We'll talk about some of the other neat things that have gone on. We'll talk about qualified retirement plans and all those other things that make up fringe benefits. And on Friday, on the June 28th, we'll talk about 199 Cap A, qualified business income, and also the TCJ portions of that. Again, this is for the Oregon Society of CPAs. We'll be there in Portland, in the Portland area, in Beaverton, Oregon, at the Oregon Society offices. Both these courses, those of you who know there are two levels there, both of these will be in the lower level office at the Oregon Society. Let's go ahead and talk about the proposed regulations on 199 Cap AG. This reg project, Reg 118425-18, IRS also issued Notice 2019-27. Both of these were issued on June the 18th. This is the last part of the regulations for 199 Cap A, and this deals with a fix for the infamous grain glitch. You may remember when the 199 Cap A rules were first passed, our wonderful 20% deduction for qualified business income, there was a problem with sales of grain and other agricultural commodities to cooperatives. In essence, well, that wasn't really a problem. You'd have saved a lot of taxes had you done that, but it would have wiped out the ability of anybody else to have purchased that from farmers, because why would you sell it to anybody except a cooperative? That wasn't the purpose of the law. Congress knew that when they passed the law. They knew they had this problem. They just expected to fix it. In March, they fixed it. These are the regulations meant to help with that fix. Now, what 199 Cap AG did was it restored the old 199 to cooperatives. Cooperatives have complained that if you got rid of old 199 and didn't give some sort of equivalent benefit, that that would put them at a disadvantage. So we wanted to do something for them, and what Congress did didn't quite work the way Congress thought it would. Now we have is the cooperatives themselves get the old 199 deduction. However, the patrons, right, will also pick that, because you're selling your grain through the cooperative, you're going to get a qualified distribution back on the sale of that product. And you're going to also get your 199 Cap A on that, except you're supposed to reduce it by a number that's supposed to approximate the benefit that was gotten from the regular 199 deduction that was incurred by the cooperative, whether or not it passes out to you. So we're supposed to do a subtraction of 9% of those qualified payments, but then we adjusted for our wages, and yeah, it gets a little messy. So it is not a perfect subtraction, never would be. Just understand the point of it. but it's meant to do that. These regs were meant to tell us how all this is going to work. Why didn't we worry about them last year? Well, because the qualified payments that are going to be made by these groups are generally going to be made in 19 and later years, because it takes at least the full fiscal year of the entity to get to where the payments would come up. So these qualified payments, the co-op must report the items of QBI that are inherent in those qualified payments, whatever their distributions. So they make their distributions. They have to tell us, is that QBI? In essence, compute how much of that's QBI, so I can then use that to compute my 20% for my farm. And also tell me, at the same time, if any of those businesses, the qualified businesses doing the qualified distribution, are there any of those specified service trader businesses? It's possible. So I need to know about that too. Now, the SSTB, I'm going to determine at my own level as an individual whether that's going to be relevant to me or not, because only I know if I'm above or below the threshold amount, and how much above the threshold amount if I'm above it. So we'll need to have all that information passed out to us. If the cooperative does not provide that information, this is where problems occur, it is assumed to be zero. We have a zero number if you fail to report it. Therefore, it means it'd be important for cooperatives to report these numbers. People don't like zero for that purpose. Okay. As I said, we make that specified service trader business determination. That's going to be important. At the same time, because it's old 199, we also got, just like we did with 199 Cap A, a notice on computing W-2 wages, a proposed revenue procedure to do that. That's also out there on this issue. Now, this is clearly a very highly specialized area. If you don't have agricultural producers who are members of cooperatives among your client base, none of this matters to you. If you do, however, especially if you're in an area where that may make up a large portion of your practice, you want to be looking for some continuing education on this particular subject that is tailored to the agricultural industry. Like when I do the session this week in Beaverton for Oregon Society, we're not going to spend a lot of time on these proposed regs. In fact, I suspect we'll spend next to nothing there, because most likely nobody in my audience is going to have these cooperative issues in play. But if I was doing a session, for instance, let's say we're talking about doing this in Iowa, then I might want to have this topic, or in certain parts of other states. There's also the issue that in some states, well, there's a little ag group, but there's also most people aren't in it, and yeah, it gets messy. So the best thing for those of you in ag to do, if you're not in a state that is really heavy into ag, is take a look for some guidance on, some coursework that comes up that might be added, because, gang, this was not known when this was coming the end of last year. So you might want to look for some webcasts and some webinars that are added, that are live ones. Make sure they're live, or if they're pre-recorded, make sure they weren't released until after these proposed regs came out, because they're not going to do you much good if they're recorded before these regs came down. Our point is try to learn these things. Now let's go to our annual June 21st, apparently it's become annual, Supreme Court tax case. This is the North Carolina Department of Revenue versus the Kimberly Rice Kaestner 1992 Family Trust. Case number 18457. The case was decided on June the 21st of 2019. This case involved the question of whether the state of North Carolina could tax the Kimberly Rice Kaestner 1992 Family Trust, based solely on the fact that Kimberly Kaestner moved into the state of North Carolina. The trust had been established by a grantor who lived in New York. The trust trustee lived in Connecticut. The trust administration books, the books and records were done, so it was administration, took place in New York, and the actual trust assets, the custodian, was in Massachusetts. The trust had no property in North Carolina, and while Kimberly Rice Kaestner and her children were the beneficiaries of the income of the trust, income beneficiaries, they received no income distributions for the year. Nevertheless, North Carolina statute said as long as you were a current income beneficiary, was a North Carolina resident, that the state of North Carolina could tax the undistributed income of that trust. The trust objected to that. The trust filed suit in North Carolina. The trial court ruled that taxing in that manner violated the Due Process Clause of the U.S. Constitution and the Commerce Clause. On appeal, because the state appealed it to the appellate court level in North Carolina, the appellate court ruled that they didn't rule on the Commerce Clause because they said all you need to worry about was you violated due process. North Carolina Supreme Court upheld the appellate court, saying, yeah, you violate due process. It doesn't work. So then finally, the state of North Carolina took the case to the U.S. Supreme Court. Now, last year when this case came down at about the same time, there was a fielding case from Minnesota. Minnesota taxes trust based on where the grantor was when the trust was established, or if it's established per a will, where the decedent was, basically domiciled before the decedent became deceased. So, that test, both of those cases, the state courts had ruled that was too broad, violated due process clause. They both appealed to Supreme Court, but Supreme Court, for the moment, only granted cert on this one. They kind of delayed dealing with the fielding case, most likely waiting for the decision on this. Well, the Supreme Court rather quickly tells you that merely being a residence for the beneficiary, if that's the only fact you've got, that's not enough. The court pointed out that to clear the due process clause, one of the key tenets of being able to do that is the state has to show there is enough of a connection between the state and what it seeks to tax. And the court found that in this case, to quote the decision, to quote the concurring decision issued by Judge Alito, the connection was tenuous at best between the trust and the state of North Carolina. The main opinion written by Justice Sotomayor, it was a 9-0 decision, unanimous decision of the court, essentially held that this violated the due process clause for the state of North Carolina to attempt to tax just on this basis. Pointed out, this beneficiary may never get a distribution of income. They didn't have any currently. And so this person had no real enjoyment, control, any way to access those assets. But we were taxing the trust based on supposedly that person being there. That was our connection, even though that connection may never see a cent from the trust. And the court said that's simply a bridge too far. Now, the court did point out that in prior cases, the court, for instance, had ruled it's okay to tax trust income if you distribute it to a beneficiary in the state. It's okay to tax trust income if the trustee resides in our state. We've had cases that said that's okay if a state does that. You've also had, the court said they had cases that suggest, basically said suggest, that if administration's done in the state, that also looks to be good enough. But none of these were true for the Kastner Family Trust as far as North Carolina went. North Carolina was trying to get it based solely on the fact that she lived in North Carolina. And they said, that's not really enough. Now, it was decided on the specific facts of the case. Couple of things to point out about this. The court told us that these are very specific. So, for instance, Justice Sotomayor, in the main opinion, tells us that you can't read anything into this case about how the court would deal with a state if it was testing whether it could tax a beneficiary based on factors other than this residency-only test that North Carolina was doing. They're not commenting about anything else. The concurrence, which was Judge Alito, joined by Justice Gorsuch and the Chief Justice, Justice Roberts, they said, this was decided purely on our old precedents. That's, if you read the decision, they tell you go read the decision, exactly what it is. And it shouldn't be read to suggest any of our prior precedents need to be revisited. So it's extremely fact dependent. Now, the main opinion also said North Carolina said, well, you can't do this. There'd be rampant tax fraud. And the court said, A, that's not absolutely clear that would be the case, because moving is, takes a lot more involved. And obviously, the minute money comes out during North Carolina can tax it. They said, and secondly, a theoretical tax dodge is not good enough to overcome the fact that you just simply don't have any connections here. They also said, North Carolina said, well, don't do this. You'll upset state taxation of trust. The states will be thrown into total disarray. And, the main opinion says, look, North Carolina is one of very few states that even looks at the beneficiary for purposes of deciding if we can tax the income inside the trust. And they said, and secondly, they're part of an even smaller group of states that claim they can do it based if that's the only thing the state has a connection to. So, and I think reality, I've seen posts on Twitter that suggest that maybe there are 2 other states that might try to tax it based solely on the beneficiary living in the state, even though distributions were in play. So they said, look, we're not going to disrupt anything. You guys don't have enough connection. It's not like carte blanche, a state can tax anything they feel like taxing. No, you got to have some connection. That simply doesn't exist here. Therefore, sorry guys, you've got to go ahead and do it the way we've done it now. Again, prior precedents were emphasized by the concurrence. So what do we know from this case? In essence, what exactly have we learned? Well, all we've learned for sure is that Kimberly Kasner, and her kids, being residents of North Carolina is not going to be able to tax this trust. We don't know much about any other state or how it's going to work in any other state. That's one of the downsides of this. We don't have any idea how the rest of this works. Rather, we're going to have to wait for future cases to see how this works. But if your state does it the way that, the justices pointed out in the opinion is okay. For instance, Arizona says if the trustees in Arizona, that's enough. And this court said, yep, that's enough. The trustee, why that works is the trustee is the deemed owner of the property. So they got the protection of the state. The state has, therefore, has enough connections with the trust since the owner lives in the state. It's enough connections with the trust property to say that they can tax the entire income of the trust. For other states, it's going to be a lot more interesting to figure out how this works. So, keep your eye on it. We'll see what happens. The next case we're going to look at is the Mihalik versus Commissioner case. I'm probably mispronouncing Ms. Mihalik's name, so I apologize for that. This is from the 11th Circuit Court of Appeals. It's case number 17-14975. It was issued on June the 18th, 2019. Now, this particular case, we have a former spouse of the taxpayer who was sued by his sister right as our taxpayer and he were in the middle of their divorce proceedings. The family member claimed that her brother, the soon-to-be ex-spouse of our taxpayer, had, committed terrible things running the family business, had taken too much money as salary, had done all kinds of malfeasance, etc., and so she's suing him for these things. Well, as the divorce proceedings going on, he says, wait, if I have to pay my sister something to settle this, because, she's being a pain, and I think I may have to pay her, you need to pick up half of this. And his soon-to-be ex-wife balked for a while, said no. He said, look, I'm not agreeing because we're basing this settlement of property on dividing things we got during our marriage evenly. And we're dividing like that money, 600, what'll be 600,000 when we finish this up. That would be used to pay off, my sister. We got that. So you should have to split this. Okay. They continued to discuss. He offered her $150,000 saying, look, give me $150 for this and I'll take you out of it. Just let me keep $150 extra. And she said no because she didn't think it'd be that much. Turned out she should have taken that offer. It finally gets settled. They finally agree. She's going to pay half. Eventually, he settles with his sister for $600,000. The taxpayer pays half of that. Now, he files his return, and he uses what's called claim of right. Let's talk about what a claim of right is. Claim of right is under Section 1341 of the Code. A claim of right exists when 3 conditions are met. Number 1, the taxpayer in a prior year reported as income an amount he or she received that they believe they had an unrestricted right to. In a later year, it's discovered that they don't have an unrestricted right, or to put it very simply, they got to pay it back. And that payback would be deductible under some other code section. If all three of those are met under the claim of right rule of 1341, you can either claim a deduction for what you paid, and quite often that's going to be a miscellaneous itemized deduction, not subject to 2% of AGI, so it even still works today. Or you can go back to the year. Now, you don't really go back and change the year that you reported the income, but you go back and you recompute the tax for that year. What if I hadn't reported this income? What would the tax have been? That decrease in tax that would have occurred back 5-6 years ago, we then can this year take as a credit against the tax for the year that we do the payback. That's claim of right. He filed for half of the $600,000 of $300,000, which he filed for because he said, I'm not going to, even though I paid the whole $600,000, my former spouse is going to pay me for that other $300,000, so I'm not going to claim the whole $600,000, even though I wrote the check. Rather, I'm going to claim the $300,000. The IRS gets his filing. They accept, and they accept what he filed, and, they let him claim the relief. Well, his former spouse, again, our taxpayer in this case, she fights again, claiming she shouldn't have to pay it. Eventually, her attorney tells her, you have to pay this. It was part of the agreement, and we really don't want to go to court because the judge will be unhappy. So she writes the check grudgingly for $300,000, and then she attempts to get her refund based on the claim of right doctrine, and the IRS turns her down. She then files suit in district court to get a refund. The district court sides with the IRS. She then goes to the Court of Appeals. So the Court of Appeals takes a look at this and decides, no, she qualifies for claim of right. Why does she qualify? Well, they say, look, we've got to look at three tests. First, first thing is, does the taxpayer appear to have an unrestricted right to the money? Well, you know what? It appears they do. They're saying, look, the IRS said, no, she didn't. They said, it was her husband's money. It's not hers. And Ohio's not a community property state, so, his is his, right? Well, no, the court said. Court said, really, the way Ohio law works in this area, half of the earnings if a married couple is considered to be, available to the party that didn't earn it. In essence, the marital couple, their earnings are split between them. Under Ohio law, they give you the statute in the opinion. They said because of that, she had a right to believe that 50%, it was her income, and she believed she had an unrestricted right to that. He had an unrestricted right to $300. She had an unrestricted right to $300. Right, we're splitting this. Secondly, they said, well, no, they wouldn't have an unrestricted right because he stole it from the company. Because we had litigation, right? His sister's claiming he did all these awful things. And the court said, IRS, no. I realized that he paid her, that he signed, that basically that we have this agreement, we're paying it back. But that was just a settlement that he agreed to pay to settle litigation. He admitted no wrongdoing, and we are not going to impose such wrongdoing because people settle for various reasons. So, you know what? They had an unrestricted right to the funds. It was not embezzled money, nor was it, a case where it was all his. She had a right to it. Now, the catch was, then it turns out later that, even though it appeared they had the right, in the end they didn't. Now the IRS objects and says, well, he paid it back voluntarily, right? It was a settlement. There wasn't a judgment against him. And the court said, no, we've had case law that tells us that as long as it is a settlement that is a result of a bona fide negotiations done in good faith, that we will go ahead and treat that as showing that we had, basically that there was a requirement to repay the funds. It turns out we did not have an unrestricted right. The court said we are not going to force everybody to go to trial to get that judgment to be able to do that. That's not the point of that. The courts are trying to avoid people going to trial. Certainly the tax law is not meant to, tell people, oh, by the way, guys, you can't settle the case because if you're going to pay him anything, we need to go to trial and have the court enter the order. Stating, have a finding by the court that it's not our money. No, they're saying that's not what we need. It's good enough. Then they said, well, what about her? Well, she voluntarily paid $300. They said, no, obviously not. She was fighting this every step of the way. So she did not voluntarily pay it. So it turns out she didn't have the unrestricted right. Then finally, can she claim a deduction? And the court ruled, the panel said there, yes, 165C1, a business loss is allowed to be deducted by a taxpayer. And the court went back to case law that showed that if a lawsuit is filed against an officer of a corporation, which is what happened in this case, he was an officer, that alleged misconduct, and the officer pays an amount to settle it, that payment is considered to be a business loss under 165 that's deductible. So she would step into the same shoes. This loss is deductible. She has a right to claim it. As such, she gets her claim of right deduction. Okay. Now, if you haven't run into claim of rights very often, yeah, they're a mess to work with. And by the way, every state handles this somewhat differently. We've had the issue come up recently. I was looking at Connecticut and New Jersey's different statutes, and for instance, as I recall the way it worked out, New Jersey only allows a deduction. Connecticut requires you to take the credit if you did on the federal return. If you didn't take credit on the federal return, you might still be able to take credit on Connecticut's return. Arizona requires the credit regardless. I mean, they're all over the place. So, claim of right's a bit of a mess, but you have to remember this thing. If you do it, you've got to remember that claim of right is there. And again, in this case, even though it was paid after the divorce, she still was able to look back and look at the tax reduction, presumably, and the court didn't get into this, but presumably we looked at the total reduction of $600,000 coming out, and then each of the spouses would get half of that reduction. And that's how they handled it. Well, the final issue for this week, let's take a look at Regulation 9868. That was issued on June the 13th, 2019, right? This case with S corporation issues with what are qualified shareholders in the S corporation. And, we're used to S's. S corporations have qualified shareholders. And if you don't have qualified shareholders, you lose your S status. So, for instance, normally, like if I have a corporate shareholder and we can't make a Q-sub election, the corporate shareholder is going to cause me to lose my S status. So if that corporation doesn't own 100% of me, and that corporation needs to be an S corp, and that corporation, has me make a Q-sub election, I lose my status. If a partnership owns shares in an S corp, the S corp becomes a C corp, loses its status. Generally, if non-resident alien beneficiaries become a shareholder, we lose our status. But the Tax Cuts and Jobs Act added a provision that said an electing small business trust that is an eligible shareholder, it can now have beneficiaries who are non-resident aliens. The IRS had issued proposed regs about 2 months ago to deal with this. They received no comments on those proposed regs, so the regs are now going final. Now, the big take, remember, an ESBT, what happens with an ESBT is all the flow-through income from the S corp and reduced by basically nothing except trustee fees directly related to the S corporation for the trust. All that income is taxed at the highest individual rate. Okay, so it gets taxed. However, what we can do now is the old regulations before the TCJA changes said that if you had an electing small business trust, something could be an ESBT, was eligible for the election to be an ESBT, but was also a grantor trust to a beneficiary, that we would ignore the ESBT rules, the grantor trust rules would take precedent. Under these regulations, if you have a non-resident alien beneficiary of the trust, even if that trust would be a grantor trust, the ESBT rules take precedence over the grantor trust rules to the extent that that is considered a grantor trust for a non-resident alien beneficiary. To that extent, whatever their share of the trust is, that's going to be not a grantor trust. Now, the trust will still be grantor trust for any other assets held by it to the non-resident alien beneficiary, but it won't be for this one. What that means is, if you're willing to use the grantor trust, if you're willing to pay the highest rates, you can now effectively have a non-resident alien beneficiary as long as the shares are put into the trust and the trust makes the ESBT election. That's kind of interesting because, again, it's a grantor trust. All the grantor options are there. So it's not as if the non-resident beneficiary can be the trustee, have the right to distribute income at will to himself, have the right to pull out corpus. He just can't pull the shares out. You got to make sure he doesn't do that. But otherwise, it works. So we can have non-resident alien shareholders. That's a big advantage. Well, it's that time of year again, right? CPE. The CPE season is running. It's summer. You might want to take a look. We've had lots of things. Developments are happening now. The big advantage of live CPE, which is the type your state society will offer you if you go to a live seminar. Live seminars have real people who are speaking at that moment and who are subject matter experts that should be able to update you on things that have happened in the last few weeks, last few months. That's not necessarily true when you buy let's say, a self-study program, because that might have been written 7, 8, 9 months to 2 years ago. It depends on what the topic is. But it's even somewhat true with some of these webinars that are live. You realize they're being rebroadcast. And that's fine. I handle those. I do some of those, and I'm the subject matter expert answering questions by email. But the problem is they're given live once and then replayed. And obviously, if they've given live and there's development before the replay, you're not going to get that development in that structure. Now, sometimes you might be able to get them updated, but usually they don't get. Usually it just kind of happens, and maybe if you're lucky, they'll send along a little note that says, oh, by the way, I know you took farming and 199 Cap A, but, we recorded that back in, early May. And, yeah, these regs are out now. So, here, maybe there's some regs. You probably need to go look at them, but they're not covered at all in our session. Live sessions, you should be able to get around that. You're up to date with real live people. You also get the interaction with other people in the room. Be sure to check your state society catalog and sign up for those. This has been Current Federal Tax Developments for the week of June the 24th. You can catch my regular updates online at currentfederaltaxdevelopments.com. Also, we post regularly there. If you have questions or comments, send them to me, Ed Zollers at currentfederaltaxdevelopments.com. You can follow me on Twitter. My address there, at Ed Zollers. I also follow the subreddit at r/taxpros on Reddit. And I follow the discussion groups on the Connect sites for the Arizona, Minnesota, and New Jersey Societies of CPAs. I'm members there, member of each of those societies. And so you can easily catch me there. Well, not so easy on New Jersey this weekend because they're in the middle of moving. And what's moving this weekend is the website and the servers that are running this stuff. So it's kind of going to be down for a while. But it'll be back up Monday morning. So I'll see you Monday morning at least if you go there. But you can post questions. If I see them and I think I can help with an answer, I'll try to chip in. If you're not a member of one of the state societies that have that, you're not a member of one of those 3 state societies, you can also join Cal CPA's Tax Talk, which is a Yahoo group. You got to go to groups.yahoo.com, search for Tax Talk, ask for permission to get in. Any licensed CPA or attorney in any state can become members of that. You can post questions there. It's a useful place to check. I check into Tax Talk from time to time as well. Otherwise, we're going to take a look and wait and see what new fun surprises are in store for us this week from the IRS. There's still a bunch of things at OIRA. Regulation projects that we expect to come down, and there's a bunch of things we know we still need future guidance on. There's lots that could happen this week, so, come back, check back next week as we discuss the big things happening in current federal tax development.